The reality is there is a line, and people have to understand the line goes something like this. To begin with, what the court had to deal with in Governor Cook's case is an unusual proceeding. We were at the Supreme Court to preserve an injunction at the district lower court level on an emergency docket, which wasn't so emergency because she's been allowed to keep her job for months, whereas the Slaughter case was in a different procedural posture. That's number one. So we do go back to the district court, but we don't go back to the district court empty-handed. We go back to the district court with the Supreme Court's majority decision pointing out what is and is not good cause to do something with a Federal Reserve Board governor. So that's first line. Second line is that the Federal Reserve Board is unique. It is a historic, different agency than all the other agencies. It is not purely ground in the executive branch. It's an independent bank. It used to be owned by private and public. It does have a unique status. If you add those things together, you can put a line, as you're asking, between the two cases. Now, that doesn't mean that the court's 6-3 opinion in Slaughter is something that people shouldn't be concerned about. I mean, not only does it take away a check and balance that the Constitution is supposed to have with three branches looking over each other's shoulder, but it forgets that these independent agencies were not started by judiciary and not by the executive. Congress was involved, and that is a little upsetting. But I want people to understand that there is something unique about the Fed, and the good news today, that institution, which needs to be independent and not allow somebody like Donald Trump to infuse it with politics, has been preserved at a much higher burden that a president has said he has, even when it came to that agency. And that's a good piece of news today.
Okay, so I don't know if I buy what you just sold. I get the idea that the Fed is unique in that it touches money. But a lot of these, the FTC, y'all know what the FTC does, right? Right? So you know what the Federal Trade Commission and all the other executive organs out there that have been created by Congress do. They touch on aspects of your life in a way that have a tripling and a quadrupling effect on families and communities out there.
You want to look at this as a policy issue, and I understand that.
Exactly.
But let me give you a legal context. One of the things that makes the Fed different is the following. It has a statute. It has an organic statute. The statute in it has as one of its clauses that it can, a person, a governor can be removed for cause. It is a agency with a fixed term of 14 years. History in the law indicates that when you have the combination of a fixed term for that period of time with Senate confirmation and a for cause removal, then it requires more from a president than it would be if it's a cabinet member or even an independent agency without that history, without that term, and without that clause.
I just one more point on that. So Abby, where I would land on what you just said is, given this court and what this court has already shown its propensity to do, in that it has not only bought the idea of a unitary executive, it has created the judicial or the legal status for a unitary executive, that this case today was just a pause, that this court, in subsequent cases that are now being fomented out there across the country to come before this court, will go after this Federal Reserve before Donald Trump leaves office. Trust me on that one.
Well, look, the president has shown anything. It's not his reluctance to press the boundaries of the law, the policy, the ethics, the morality, you name the adverb or the adjective. But the Supreme Court did something important today. It set out that a president, whether it be somebody as ill-motived as Donald Trump or somebody who just thinks that the Fed ought to be doing something different for all the right reasons, if that's possible, can't just do it the way it does it for every other agency, both in terms of what the process a federal governor is required to get and what would or would not be cause for removing in that statute has been set out by the court. I mean, one of the things that was interesting today was that it was a 5-4 decision. After the argument in January, people thought it might even be a bigger swing than that. And I think one of the reasons it was close was two things. One, the court went out of its way to definitively state that this statute, this Federal Reserve statute, is constitutional with its provision for cause and less power to the president, whereas it ruled that a similar statute for independent agencies was unconstitutional. That's the yin and the yang. The second thing it did is, in cause, it said, okay, we're going to look to what's called the common law, so the president shouldn't just trifle with it. I think what you're asking is this. Should people at the same time be grateful may be relieved that the Federal Reserve Board stands independent. It should. Should people be concerned that this court is willing to give what the president said is the power that he thinks he deserves as the president, more power against 90 years of this precedent in the law? And in the way we hope that one branch of the government will check the power, they should be equally concerned as they should be grateful about the other decision.
I want to talk to you about Bill Pulte, if that's okay, because Bill Pulte is now our acting DNI director. But before he got this job, not confirmed, by the way, but he's our acting, he was the director of the Federal Housing Finance Agency. And he is the one who brought up these allegations of mortgage fraud against your client. He said on X today, as I've repeatedly said, I believe Lisa Cook will be indicted for mortgage fraud. Two-part question, A, your response to that, and then B, is Bill Pulte qualified to be the DNI director?
All right, so the answers to all those questions fit together. Not only did Bill Pulte make this baseless allegation against Federal Reserve Board Governor Cook, which started that, also did that earlier with New York State Attorney General Letitia James, who I help advise, and has done so for Senator Adam Schiff and others. There's a couple of things about that so-called mortgage fraud. As we pointed out in the Cook briefs, it's really interesting that these same alleged disparate entries on mortgage applications were done by members of Donald Trump's cabinet, and you don't see him asking them to resign. Back to your question about, Bill Pulte. He took an agency, the FHFA, that was put in place to help Americans get better housing, more affordable mortgage, and turned it into a mini FBI as part of the weaponization of this administration. That is not something that people should not, they should not forget that that's what he did. And now he's at DNI. And DNI is an agency where he could do the exact same thing. And I know it's supposed to be temporary, but he's there for now and how long. To answer your question about his competence to do that, I don't have a good analogy, but putting Bill Pulte in charge of DNI would be like putting Mr. Magoo in charge of building your house safely.
I do think real quickly that if you have someone who is in charge of an obscure housing agency, and they're able to weaponize that, one can only imagine what will happen when you have the entire disposal of the U.S. and national intelligence apparatus ready to go.
Abby, it does seem like, though, that the justices left the door open for the president to try again to remove Lisa Cook. So how are you preparing today, despite this victory?
So it's what I said before, Jackie. They didn't just send it back without any owner manual.
Yeah.
There's a little owner manual. And we will use what the court said, because there are many important principles in the majority opinion that sets out a couple of things. There are two challenges we made to the dismissal of Governor Cook. One is that it was done for improper purposes, perhaps pretextual, as we may have to prove.
Right.
But the second is that they didn't give her the proper notice and opportunity to be heard that everybody should get in the due process clause in the Constitution of the United States. So the Supreme Court sent it back, which is, remember, we were in an emergency. Please don't take the merits, which was what some of the dissenters were talking about, by the way, which is why are we delving into this at this point? All right, that said, it goes back with parameters. It goes back with some binding principles. And I know that in a moment of peak, Donald Trump revealed his hand again when he weaponizes his agencies by already saying, guess what? We're going to do it again, or we're going to take the full effort of the law to go after her again. By the way, when the Supreme Court says, give her due process and make it for cause, and the President of the United States says, I've already made up my mind, he's probably proved the point of what the Supreme Court was trying to protect against.
So, Abby, before we let you go, I want to broaden out the conversation a little bit, because you are a well-versed lawyer who's been a student of not just the practice, but the history, and understand how these pieces come together. When you see a court that is so ready to undo precedent, stare decisis, the idea that these so-called conservative justices berated Democratic administrations and Democratic nominees over this idea of originalism and the history of the things, that they're so willing to crap all over that. And that's
the legal phrase.
That is the nicest way I can put it at this hour of the day. What does it say that a future Congress and a future administration need to do with respect to the direction our court is heading, and just how quickly they have submerged themselves into the quicksand of politics?
Well, that is the yin and the yang. I'm using that phrase a lot today of that point. Look, Supreme Court precedents are supposed to have some bearing in time. And in extraordinary circumstances, and we've had a few in our country, most significantly in the 19th century, the decision in Plessy versus Ferguson that stood for too long before it was eradicated later in the 20th century. It is possible and important at some point to look at stare decisis and say, we made a mistake. That's supposed to be the exception to the rule and not the rule. And over the last decades, especially in things important as women's ability to pick their medical treatment themselves and other such fundamental rights, there has been the ability to not pay much attention to stare decisis. Why is that? People are debating it. I think there are a few reasons. I think one is the politicization of the courts, where people are picked with a litmus test, where another issue is that we have lifetime appointments for all the judges, including the Supreme Court. The third is that the President of the United States in his first term and in this term has basically said to the world, when they do what I want, they're right. When they do what I don't want, they're wrong.